Tonight, what does the data reveal? A digital forensics expert goes through Google searches from the morning John O'Keefe was found.
What I can state to a scientific degree of certainty is that that search occurred at 6:24 a.m.
How a timestamp on a controversial question is becoming a major focus for both the defense and prosecution. Plus, we take a deeper dive into the voicemails that Karen Reed left for O'Keefe. Could they be viewed as a diversion tactic or messages to prove innocence? Canton Confidential, the Karen Reed murder trial, starts right now.
There was a lot of talk about an online search by one of the key witnesses in the hours before John O'Keefe was found dead in the snow. Good evening, everyone. Thanks for joining us tonight. I'm J.C. Monahan.
And I'm Glenn Jones, a digital forensics expert on the stand, walking us through when the House Long to Die in Cold search was made on Jennifer McCabe's phone. Let's go to our Melody Mendez. She joins us live tonight outside Norfolk Superior Court with more. Mel, good evening.
Good evening, Glenn and JC. Here's the thing. It's that Google search that was squarely the focus in court today. It took up the majority of the time in testimony. Take a look.
To a reasonable degree of certainty, I can say that Ha's Long to Die in Cold was searched at approximately 6:24 a.m.
On day 11, the prosecution bringing in a second digital forensics expert to say when that search was made. Jessica Hyde took the stand just before noon, but the arguments surrounding her testimony started well before. Jurors were sent out of the room while defense attorney Bob Alessi argued that they should be allowed to cross-examine Hyde about her involvement in a case in Maryland.
Her testimony on 227 is not reliable. I'm not looking to exclude it. I'm looking to cross her on her reliability.
This is an attempt to try to malign a witness with something that's wholly unrelated.
Judge Cannoni eventually ruling the defense could not reference the Maryland case in their cross-examination. Similarly to what we heard from another expert last week, Hyde said that McCabe opened a tab at 2:27 a.m. for something unrelated, left it open, then used the same tab for the Google search hours later.
There is a timestamp for the search Ha's Long to Die in Cold. However, that timestamp isn't about active searches. It's about the time that a tab was either opened or moved to the background. There's a really scary danger that an examiner who has not dug into the artifact and tested to see what it means may assume erroneously that 227 timestamp is the time that what is there is searched.
During cross, Alessi asked about her communication with State Trooper Brian Tully while working on her analysis.
And I'd have to review my call logs. I'm not going to test.
More than 10.
More than 10, I'm sure.
Tully was a commander in the detective unit, but later transferred out amid an internal affairs investigation. Tully was one of Michael Proctor's supervisors. On redirect, Brennan asked if she was ever asked by anyone to reach a certain conclusion.
My analysis was independent of the district attorney's office.
And she was asked about the Apple Health data on John O'Keefe's phone.
You note under the data that John O'Keefe's phone registered 80 steps at 12:21:10.
Defense attorneys have attempted to show that those steps prove O'Keefe entered Brian Albert's home. The prosecution says there's no evidence he ever went inside. All right, now, once that expert was finished with her testimony, we saw another media clip of a Karen Reed interview that was played. Court resumes at 9 o'clock tomorrow morning. We'll be here for it all. Glenn, JC, back to you.
Mel, the defense spent a lot of time yesterday on the police work in this case. Did that continue today?
It did. You know what? Specifically, they asked the expert witness, Jessica Hyde, to speak to John O'Keefe's phone in the hours after his body was discovered. Specifically, they wanted to know whether that phone was put in something called a Faraday bag. So essentially, that's a device that's designed to shield any signals from getting to the phone or leaving the phone. So essentially, it's to, if you want to think of it as freezing a phone in its current state. Nothing can change about that phone once it's in that Faraday bag. But when asked if that device was put into a Faraday bag right away, she said it is best practices to do so, but she could tell from the data that it wasn't done until noon that day, confirming that if it's not in a Faraday bag, data can be overwritten on that device. Glenn, JC.
All right, Melody, thank you. Joining the conversation now is our chief legal analyst, Michael Coyne, as well as attorney William Kickham. Again, as always, thank you both for joining us. Yeah. Melody just mentioned that Judge Cannone denied a defense's request to bring up this other trial that happened in another state. She said not relevant to it. There was a lot of back and forth on this. There was a lot of numbers, but also a little human moment. Take a listen to what Judge Cannone said coming out of the lunch break to the jury.
And I can't stress enough that this should have been brought up before today. So I'll hear you about your concerns, Mr. Alessi. I'll hear the Commonwealth's response, then I'll go finish reading everything else you gave me. I get frustrated at lawyers about something. I try not to, and I don't think I am. But if I seem to cut somebody short, the lawyers are just doing it.
All right, Michael, William, Judge Cannone clearly trying to keep this trial moving without having any interference in the actual process. What did you think of the moment? That moment right there in particular, that she's basically saying to the jury, you know, if I sound frustrated, disregard.
Humanity 101. Yeah. I mean, this is a very tense environment. It's very filled with all kinds of biases and thoughts and positions, and you can cut it with a knife. And she's trying to be human. She's trying to say, without saying it, I'm human too, I'm a person too, I can get frustrated too. If I sound frustrated to you, I don't mean to be. That kind of thing, and it comes across well.
And you don't want your actions to influence the jury. You don't want them thinking you're mad at one side or the other, or you're curt with one side or the other, because that could potentially sway jurors one way or the other. So what she's doing is, out of an abundance of caution, making sure early on that they understand, you know, things that I say things, the lawyers say things at times, focus on the evidence.
And basically saying lawyers are doing their jobs.
Right.
Whatever my response, they're doing what they're supposed to be doing.
So once that hearing was solidified, Jessica Hyde was allowed to testify. She focused on the timing of the much-debated Google search, House Long to Die in Cold, which was found on Jennifer McCabe's phone. The defense has maintained for years that search was made at 2:27 a.m. before John O'Keefe's body was found. Hyde says the search was really made at 6:24 a.m. According to the prosecution's expert, the 2 a.m. hour was when the browser tab was open, not when the search was made. And that's the source of the confusion. So I am almost afraid to ask this question. But what's the net? When did this search happen?
The jury will decide exactly what the facts actually are. Because as you noticed, they have an expert coming. She even testified today that their expert is well regarded in the field as well, and they are going to say the exact opposite, that the search was somewhere at around 2 a.m. that morning. The jury will ultimately have to sort through and figure out which expert is more credible, what the facts actually are.
And Bill, lay out for us why this is so important.
This is critical because if the search was made earlier in the day, it points to a certain degree of culpability or guilt. And if it was made later, it doesn't. And you've got two experts for the prosecution, Ian Whiffen and Jessica Hyde so far, and we're going to have expert witnesses for the defense.
No doubt.
And it's going to come down to credibility. What do these jurors see in each of these experts? Is there a nuance? Is there an inflection of the voice? Is there body language? Is there something that can lead a juror to say, I think it was this time?
Well, when it came to the defense, Leslie got up there and really was, very heated at times with this expert. Yes, she's getting paid by the prosecution to have done the work, but at the same time, her work is her work. So did the defense make any progress with that? Because from an outside perspective, just from mine, I kept trying to see where Alessi was trying to land with his points about, is her timeline correct? Is she using the correct numbers to try to prove she's wrong, that it did happen at 2:27 a.m.?
He's hammering in on two words that mean everything. Reasonable doubt. Can you be absolutely, positively, scientifically certain that that call was made in the morning?
Do you think
I don't think he landed. I would call her a Teflon expert. The fact is, everything, she owned up to what she had to own up to. Yes, you read that correctly. She never really faltered. She held out on the line, and she gave us at the end that phone never moved from 12:32 that morning from wherever it was located. And that's a big get for the government. That shows he never got in the house and that he never wandered too far from where he exited the vehicle. She was a strong witness for the government.
Yeah, I'd agree.
Today's first witness was State Trooper Connor Keefe. He's a digital forensics examiner and helped process the scene at 34 Fairview. While on the stand, Trooper Keefe showed the court pieces of evidence, taking out one of John O'Keefe's shoes and pieces of broken taillight. And that leads us to a viewer question about handling evidence more generally. Crystal from Texas wants to know, if there is an expert witness or investigator handling one piece of evidence with gloves on and then handles another piece of evidence from a different secured bag, is that not a potential for cross-contamination? Michael, why don't you start us off on this one?
Yeah, yes, it is, potentially, except all of the testing and all of the study has already been done. So when they're revealing it in court with the gloves on, the testing, all the results are already in place. And so they're not really going to contaminate it. If you were to test it post that, then potentially you have that risk.
All right, William, then I'm going to ask you this viewer question. It focuses on legal terminology and the first trial. So Caroline asks, in regards to Karen Reed's lawyers and even some witnesses, quote, I've noticed they correct themselves when they use the word trial when referring to the first trial and correct themselves to use the word proceeding. Are they not allowed to allude to the previous trial at all? And if so, why not? Is the jury not supposed to take into account that there was a mistrial or even a first trial at all?
This is an interesting exercise in semantics. The prosecution doesn't want to use the word trial because they don't want to be perceived as persecuting. And the defense doesn't want to use the word trial because they don't want to acknowledge that there's a prosecution going on. And so you're going to hear proceeding chosen in a long time in many ways instead of trial.
And they also use proceeding with respect to the grand jury. So they refer to it almost generically, both their trial and the grand jury proceedings as proceeding.
Well, you can see why people get confused.
Absolutely.
You know what I mean?
Absolutely.
If we're just going to dance around it and they can't, but that makes sense. This is all perception and how people are taking in information. You don't want to be the bad guy.
Right.
And the silly part of it is everyone who is in panel knows there was another trial. In order to be part of this jury, we had to carefully question them to make sure they wouldn't have listened to the evidence from the first trial and only use what's received here. So
they're all aware.
Yeah.
And yet, the dance continues.
The dance continues.
It does.
Gentlemen, thank you.
William, thank you for coming. We'll see you again. Michael, we're chaining you to the desk. Stick around.
I'll be here.
Up next, how does today's testimony compare to what was said by the same digital forensics expert during the first trial? Stay with us. Our courtroom insider, Sue O'Connell, is joining us. Plus, we're answering more of your viewer questions.
And before we go to break, we want to take a moment to remember John O'Keefe, the victim in this case. The Braintree native was a father figure who stepped up to look after his niece and nephew after an unimaginable family tragedy. Canton Confidential, the Karen Reed murder trial. We'll be back right after this.
Don't miss any of the Karen Reed murder trial. Get the full recap of what happened in court, expert analysis, and what we could see next. This is coverage you won't see anywhere else. Canton Confidential, weeknights at 7 on NBC 10 Boston.
We're back now with Chief Legal Analyst Michael Coyne and Courtroom Insider Sue O'Connell. So, Sue, you were there for Jessica Hyde's testimony and cross-examination today, as well as in the last trial. So what are some of the differences you're walking away with?
Well, one of the big differences is the cross. David Yannetti didn't do very much of a cross at the first trial. This time, the cross was sort of the main piece of what we experienced today. As far as her testimony goes, it was pretty much on point. I mean, she also used the restaurant analogy to explain where things go in your phone when you're deleting them and they wait in the wait area. So that was on point. And I think that I didn't compare word for word, obviously, but it looks like she was more certain in her reports this time when she was presenting that the search didn't happen in the 2 o'clock hour, that it happened in the 6 o'clock hour.
It's just it was very dense.
Yes.
You know, a lot of tech talk. We had a little of that with the meteorologist, but this was a lot of tech talk. And we know because we've brought in the former juror from the first trial, Ronald Anastasio. I swear I'm never going to get that name right. So he talked about how this kind of expert testimony in the first trial went over with the jury. Take a listen to what he said.
I think there's still that piece of reasonable doubt because it's not very clear, right? So in a juror's mind, just like when I perceived it for the first time way back then, it seemed like it's not very clear, right? You have this expert who's saying they're an expert, but it's not very clear in my mind or in anyone's mind, right? If you look up something, can it happen now or can it happen in the future, right? So it's still unclear in my mind. I don't know if it's going to resonate in the jurors' minds.
I know you are looking at those jurors, Sue.
Yep.
Does it look like it's registering?
Well,
Light
again,
bulbs
they're a
going
very
off?
stoic group, and they take a lot of notes, so they're not giving me a lot. But, you know, you do see people kind of considering things when they're talking about the number of phone calls that, you know, eventually 7 layers down, they get deleted. You have 200 calls that are on your log, 200 WhatsApp on your log, 200 FaceTime. So you can see those things registering. But I have to say, even for myself, just for me, I have been in the technology world since like 1992. I've run websites, I've built websites, I understand. I've heard testimony like this now 4 times, and I still get lost, right? Understanding. And to his point, to Ronald's point, we're going to get another expert up who's going to say the exact opposite of this and be probably just as convincing in a different way. And again, I think the jurors are going to look at this if history is our guide and say, I don't know. But the one thing we have different is we have Kerry Roberts saying that, you know, that she did not now say that she heard Karen tell Jen McCabe to do that search. So will that piece of real life testimony and evidence, is that going to come into play in their closing?
Michael, let me approach this from a different angle. Do I need to believe that this search happened at 2:27 a.m. in order to acquit Karen Reed? Are the two things tied together?
No, those two things aren't tied together, but we are looking at this search microscopically. In order for this search to matter to that extent, you have to buy in that he was killed in the house and a group of people that conspired to then leave him out on the front lawn. I think that evidence is lacking. So if this is the linchpin for that, it's up in the air at this point whether, in fact, you're going to decide that this how long to die in the cold is really that important. They've got to have other evidence that support the meaning of this in order to make it work.
Sort of a series of building blocks.
Big blocks,
yeah.
Big blocks.
All right. Now, we want to circle back to those voicemails Karen Reed left for John O'Keefe.
Yeah, it's 1 in the morning. I'm with your niece and nephew. You pervert. You're a pervert.
Okay, we're not playing all of those. That was just a few of the 8 voicemails that Karen Reed left on John O'Keefe's phone in those early morning hours before he was found outside 34 Fairview. So, Sue and Michael, this got some of our viewers talking. Beth wrote in asking, regarding the numerous phone calls, if she was so desperate to talk to him, why didn't she turn her car around and go back to the Albert house to talk to him? I think she was creating an alibi. We can't get into Karen Reed's mind, right. But to the point of this viewer, Beth, was she creating an alibi?
Well, I think, honestly, if she was creating an alibi, I think she would have done a better job creating an alibi, because calling and yelling at him, this angry vitriol with all these insults, really does say they had a fight before he got out of the car, regardless of what happened. So I think that it doesn't necessarily say that she did or didn't do it, but it's just not the best airtight alibi. If I was going to make an alibi, it would be, honey, have a great night at the house. I'll see you later. I would not be doing that.
All right, Michael, listen to this one, because a viewer asked almost the exact opposite thing. Albert in Merrimack wrote in saying, with the amount of calls, texts, and voicemails made to O'Keefe, if, quote, it appears to contain a level of either innocence or ignorance, as she is obviously unaware of John's position at that time. Do those messages help or hurt the defense, Michael?
They do both, because it now is clearer to me why the jury in the first case could reject count 3, listening to those voicemails saying, well, she didn't know she hit him. The problem is that they are full of invectives and hate, and some of the counts really talk about being reckless and intending to kill him. I think there should be no doubt that if, in fact, she's convicted on counts 2 or 3, the DUI manslaughter or count 3, leaving him to die in the cold after having hit him, it will be because of her words. Her voicemails and all the videos that we've heard so far that she never should have given.
Speaking of which, we ended the day again with a clip from that documentary where Karen Reed was saying, if it has to be Jen McCabe or me, you know, so be it. It's going to be me. How did that
It's
land?
going to be Jen.
So, right.
Depending on how you look at it, yes.
So, JC, again, it's not a TV show, so the TV person in me is frustrated. We had this really long, dense, Hoss-long Google search testimony that we were all squirming about waiting to end, and then Brennan, Special Prosecutor Brennan, plays the clip, and then the lights go right up, and then Judge Cannoni says, okay, jurors, that's it for the day because we're on schedule. So if it landed, you know, we'd say give it a moment to marinate, right? We'd say give it some air. They don't get that. But I asked Michael before the show, do they get to bring these clips with them during deliberation? And he says yes. So I think that's when we'll find out if it actually, I mean.
Well, they'll hear it again in close as well.
Yeah,
he will emphasize the most important ones during his close. He'll put them in context. He'll tell the story and wrap it all up. And a lot of times that is what you do in the close. You now pull a lot of things that people say, well, why is that? Why is that? The story in the close will tie all this together. And he will do it because he's a great storyteller.
And a reminder, the defense hasn't told their story yet.
Right, that's
so
correct.
they'll do the same thing using clips.
They'll tie all of this together at some point as they start putting their evidence in. They will get to offer some clips in order to put some of these comments in context, but they won't have the same leeway that the government does.
Michael, Sue, as always, thank you so much.
And remember to join us every weeknight at 7 on NBC 10 Boston. We'll have a full recap of the latest developments from court as well as legal analysis. Plus, this week's episodes will be streaming on Peacock starting on Sunday. You're watching Canton Confidential, the Karen Reed murder trial.
Watch LaToya Edwards and Raul Martinez weekdays at 6 a.m. on NBC 10 Boston.